dated 3/1/1956 in service settlement of 1964. The name of the position which defendant and defendant number 2 and 13 were duly recorded in the record of right. Although name of the Bihar Sarkar was...
There is enough reading that this property was purchased from a joint family.
No.
Yes.
No, that is the different plot property lots.
No.
And there is no dispute lots.
No, you just read paragraph 25, 26, even 24 for that matter.
I am reading 21.
Read 21.
21. That it is very curious to note that the deceased plaintiff Lakshman Sharma had not made any whisper about the holding number 94, Sakshi Market, Jamshedpur, which was once acquired by this defendant in the name of K. Mahapatra, nephew of the defendants, son of the elder brother of the Markandeya Patra, subsequently in the name of the deceased plaintiff. तो खुद ही बोल रहे हैं, खुद ही बोल रहे हैं कि मेरे हाँ पढ़ रहे हैं plaintiff, and also about the land of plot number 3. This is not the subject matter of the substantive question of law. The lands of plot number 351 is in the Moja Gandhara PS Telco measuring 0.7 acres of the deed of sale 23/7/1951 in the joint names of this defendant, and the deceased Lakshman Sharma has also about another portion of plot number 352, which was separately acquired by this defendant by means of registered deed of sale dated 7/3/1967 for valuable concession. Besides the above, some lands in Moja Gandhara were also acquired in the joint names this defendant and Lakshman Sharma, which measure 0.40 acres. The defendant also acquired 3.75 of the agricultural land in his native place at Odisha in village Bisra and Sadapur. The defendant number 1 also first acquired the soap number, this is important, soap number 94 of Sakshi in the name of his nephew K. Mahapatra and one Kumar Parida for 5 years by means of the registered sale deed dated 17/11/1964.
For 5 years मतलब 5 साल के लिए क्या?
नहीं आगे बढ़िए. Thereafter, as the owner of the said property was highly indebted and expressed his desire to sell the same, it is the defendant who bought the said property purchased in benami name of Lakshman Sharma. खुद ही बोल रहे हैं लक्ष्मण शर्मा के नाम से परचेज किया गया है. एग्जिबिट भी देख लिया, खुद ही बोल रहे हैं.
तो जॉइंट फैमिली है ना, जॉइंट फैमिली में वो बोल रहे हैं कि आप लक्ष्मण शर्मा के नाम से.
तो उसको प्रूव ना करना हो कि जॉइंट फैमिली का कहाँ कोई एविडेंस नहीं.
Is there any finding that there is a disruption in the joint family?
No, there is no.
There is no such finding.
There is no finding.
There is no such finding.
But according to section 101, Lordship, of the evidence, who has assets has to prove, Lordship.
That's right. That's right. But the point is.
But it is registered sale deed in the name of Lakshman Sharma, Lordship. It is a sale deed is a Lakshman Sharma, Lordship.
In a family, when there are multiple properties and one is buying property in the name of his son, sometimes he's buying property in the name of his nephew, sometimes he's buying property in the name of his brother. Then under such circumstances, that particular property will become the exclusive property of those persons in whose name it is purchased.
Yes.
Yes, yes,
yes. Because the sale deed is in the name of the original plaintiff.
And this is purchased prior to 1971 Act. Benami Transaction Act कब आया?
उसको बाद में आया.
बाद में आया ना? तो ये सारे transactions पहले के हैं.
पहले के हैं.
हाँ तो पहले वाले transactions को annul थोड़ी किया है Benami Transaction में.
नहीं उसको तो
annul नहीं किया है ना. तो इसीलिए in a particular family when there are multiple persons are buying property in various names. And ultimately, it is held that because there is a story of previous partition also. That must have been disbelieved. Is there any finding on previous partition?
No, there is no. The learned trial court held the partition all the suit properties, but included the holding number 94. But there is no dispute, Lordship, the partition by the learned trial court or appellate court, Lordship. There is the dispute is holding number 94.
That's right. But once there is a nucleus in the family, and otherwise the family is joint. Then under such circumstances, if one of the party asserts that yes, this particular property was purchased in the name of his nephew or his brother or whatever, then that has to be included in the partition.
Earlier, this property was leased between the Jagannath Sahu, between the Lakshman Sharma and Surinder Sahu. And Jagannath Sahu sold the land to the plaintiff. May I see Exhibit 6 by
Lakshman Sharma is the plaintiff.
Lakshman Sharma is the plaintiff.
Now let us, this is exhibit number?
This is exhibit number A by 6. Exhibit A by 6.
You just complete reading this. You complete the price number.
The defendant number 1 has first acquired the shop number 94 of the Sakshi market in the name of his nephew K. Mahapatra and one Kumar Bar Parida for 5 years by means of registered deed dated 17/11/1962. Thereafter, as the owner of the said property was highly indebted and expressed his desire to sell it. It is this defendant who bought the said property purchased in the benami name of deceased Lakshman Sharma after collecting the sum money by selling another store as Baredi Jamshedpur being shop number 6. The defendant also jointly acquired another vacant land in Mohoradi with the Chetan Saw, Sagirathi Chaudhary, Ganga Prasad Shukla, measuring about 0.6 acres. The said land was acquired by this defendant, said builder in their joint names along with the name of his aforesaid brother Lakshman Sharma, and also in the name of his then minor son Srinivas Sharma. There's sometime in about year 1960, the chronic dispute and the differences arose between the family of the defendant and his eighth brother Lakshman Sharma, in which it was no longer possible for them to run the aforesaid business by the defendant number 1 with the help of said Lakshman Sharma, for which a family arrangement was made on 16/3/1981 for smooth and distribution to the property as Jamshedpur between this defendant and his brother Lakshman Sharma in presence of the party in the locality and also in the presence of K. Mahapatra. In said arrangement, the another building of the schedule A was allotted in the share of this defendant.
The entire building
Was allotted in the share of the defendant along with the aforesaid property buried to remain after the sale of shop number 5 of the said area. Absolutely, the aforesaid with business in holding number.
the aforesaid shop.
थोड़ा सा मेरा मीटर होता है aforesaid shop with the business in the holding number 94 acres. Also the aforesaid agricultural land of the Birsa and
The aforesaid entire property
the
of
aforesaid
Moza Gajra.
थोड़ा सा मीठा होगा. Also the aforesaid agricultural land of Birsa and Dada Post village in Sundargarh district, Odisha, measuring 3.75 acres, were all allotted to the said Lakshman Sharma. Absolutely. Similarly, K. Mahapatra was allotted the Rourkela shop. None of the defendants or the said Lakshman Sharma or K. Mahapatra had any right in the title, interest, or lawful possession over any portion of the suit property which were allowed in the share of other in the said aforesaid arrangement dated 16/3/1971. This defendant therefore continued to become the absolute owner of the schedule A property and business being run by him in the ground floor of same. At present, this defendant is running a clothes shop as well as government fair price shop in the ground floor of the said house, exclusively unconcerned with the plaintiff or their predecessor Lakshman Sharma. That after the said family arrangement dated 16/3/1971, the parties started enjoying their respective property allotted in the individual name and absolutely and exclusively at the said Lakshman Sharma thereafter sold away himself the aforesaid entire landed property of the Dadara Mauja, which was within one compact block with his elder son of the Prajot Shekhar Sharma by means of registered deed sale dated 5/2/1970 for valuable concession to Usha Devi Mishra and enjoy the said proceeds themselves exclusively unseen with the anybody. These facts, along with also sole corroboration about the properties allotted to the share of the property in the said family arrangement dated 16/3/1971, that from the above fact it will be crystal clear that the plaintiff and deceased Lakshman Sharma have deliberately suppressed many facts and have not included the sum considerable amount of the property, that is of the Gadara holding number 94 Sakshi Bazar, which have acquired in the joint selling of the parties unless the same are included in the this is a wrong statement also.
It is not acquired in the name of
The holding number 94 were not the joint names of the defendants and the plaintiff also. This is a wrong statement. That the statement made in para 12, 13 and 14 of the plaintiff, all are the false and hereby denied. The plaintiff have absolutely no share or any concern any of the, ये तो बोल रहे हैं किसी में हमको share है ही नहीं, any of the suit property and this is Lakshman Sharma
इनका कहना है कि previous petition में आपको जो allowed हुआ था उड़ीसा वाला था।
हाँ, तो इसीलिए से कोई पार्टीशन नहीं हो सकता। दोनों को बोला है कि सब सभी प्रॉपर्टी का पार्टीशन होगा, included the holding number 92. Basically included the property which were not only self-acquired of the defendant but were also exclusively allotted in the defendant in the corporate family arrangement of 1970. So far as Schedule 8 property is concerned, which is the main target of grabbing the property by deceased Lakshman Sharma and other body, which all self-acquired property of this defendant, he had allegedly left out the property as stated above. In view of the above submission, the K. Mahapatra and other nephew are necessary party to be sued, as well as the transfer the deceased Lakshman Sharma Usha Devi.
How many written statements have been filed?
According to us, only 2 lots.
This is on behalf of written statement on behalf of defendant number 1. Okay. There is one written statement on behalf of
performer defendant number 12.
12. What about other defendants? The proceeding was ex parte.
I have only 2 defendants. There are 2 written statements in my record laws.
You must have seen it in the impugned judgment. It must be mentioned. And what is the stand of pro forma defendant number 12? Who is pro forma defendant number 12? According to you.
He said that he has been unnecessarily made party para 3 lots. That the defendant has been unnecessarily made a party in the suit and property mentioned in the Schedule C of the plaintiff have also been unnecessarily made subject matter of the suit property, which the plaintiff or their deceased predecessor have or high court vote in the right title interest of possession of the thing. The area of the state lands are only wrongly described. He said that he has been unnecessarily made party. The exhibit 6/9 is also.
Has the plaintiff mentioned anything about the family arrangement?
Family?
Arrangement. Is there any statement of the plaintiff with regard to the family's arrangement of 1971?
Very fine.
the plaintiff himself is saying that not many properties were purchased in joint names, in the name of other persons.
But not there.
In the name of
But did not say the
members.
holding number 94.
That's right. That's right. Holding number 94 is
94, there is no specific statement, Lords. And also admitted Lords.
Let us see the judgment.
Trial process. Before the Lordship, can you see the exhibit 6 by 9 Lords? Earlier Lordship.
6 by 9.
6 by 9.
This document that you have given. For exhibit.
There is a lease. There is a lease between the Jagannath Sahu, Lakshman Sharma, exhibit 6 by 9.
9.
This-
Lease between. We'll take it out from here.
lease between the Jagannath Sahu, lease Jagannath Sahu between the Lakshman Sharma and Surinder Nath Parida. And thereafter, Lord Sri Jagannath Sahu also sold the land to the
Jagannath Sahu and
Lakshman Sharma and Surinder Nath Parida. Exhibit 6 by 9.
what is the date of this lease deed?
18th of December 1962.
18, 12, 1960. Okay. One side was Jagannath Sahu and other side was Lakshman Sharma and
And
Surinder
Surinder Nath Parida.
Parida.
And thereafter, Lord Sri the Lakshman Sharma sold the land.
Lakshman Sharma purchased, no?
Jagannath Sahu sold the land to the original plaintiff Lakshman Sharma by virtue of registered sale deed, Lordship, in the year 1968, which is the dispute before this honorable court.
This is 12/8/1968.
Lords.
This is exhibit number 6 by
Exhibit A by 6, Lords. A by 6.
6 and 6 by 8.
Lease वाला है 6 by 9. जो lease
These
हुआ
are
है
6 by 9 and
Six
this is 6
and-
by 8.
exhibit 1 by 6.
No, this is exhibit 6 by 8. 6 and 6 by 8.
6 by 6. I'm sorry, I'm
6 by 8. Okay.
it is proved that it is a self-acquired property of the Lakshman Sahu. Lords. There was a previous lease between the Jagannath Sahu, Lakshman Sahu and Parida, and subsequently Lord Sri Jagannath Sahu.
These dates cannot be related to this.
Thereafter the Jagannath Sahu sold the land.
Important is from where is the consideration from. So at the time of sale,
But it has been alleged by the defendant number 1, who has to prove whether it is purchased by the joint family property or not, according to section 101 of the Indian Evidence Act, Lords. And also I will show the judgment, Lords.
you see when a person is, when there is a joint family and a person is claiming that a particular property is his self-acquired property,
I am not claiming.
whosoever is claiming that it is the self-acquired property, then that party has to plead and prove that it is
Yes.
the self-acquired property.
Yes, I am saying, Lords.
The contention of the defendant in this case is that the plaintiff has not included holding number 94, although it was the joint family property. But you are claiming, though not in the plain, but by virtue of the written statement, the stand taken in the written statement, that it was your self-acquired property. Who will have to prove it?
By the defendant.
No.
By the
Just-
defendant.
Defendant is saying that holding number 94 is not his self-acquired property, but is a joint family property.
Once again, Lords, para 21, we kindly read, Lords.
Yes.
Of the written statement.
Yes.
Para 21.
Yes.
Yes, it is very much clear to note that the deceased plaintiff Lakshman Sharma had not made any whisper about the holding number 94 Sakshi Market, Jamshedpur, which was once acquired by the defendant in the name of
By
K.
this defendant.
In the name of K. Mahapatra, nephew of this defendant, son of a elder brother of Markandeya partner, and subsequently in the name of deceased plaintiff. Also about the lands of the plaintiff.
And subsequently in the name of deceased plaintiff.
This is absolutely
and
wrong.
Also about.
It is absolutely wrong statement. A real lost lease between the Jagannath Sahu.
You forget about that. There is an arrangement of lease between two persons.
Yes.
Right? But when the property is subject matter of sale, what is important is from where the consideration is flowing. In the case of a joint family,
was paid by the Lakshman Sharma Lordship.
So if the consideration was paid by Lakshman Sharma in the joint family setup, right? Who has to prove that the consideration was paid by him?
By the defendant who alleged.
If Lakshman Sharma is saying that it is self-acquired property, he has to prove.
I am not saying the same. There is no statement relating to holding number 94.
94.
How can I say that whether it is a self-acquired property or not, Lord?
The plaintiff has not included holding number 94 under the assumption that it is a self-acquired property, right?
Yes, correct.
So therefore, if the plaintiff is not including a particular property under the assumption or under the belief that it is a self-acquired property or under a legal situation that it is a self-acquired property, and the defendant say that no, it is not a self-acquired property, but it is a joint family property, right?
But no point was raised relating to partial partition lots. Therefore, lots, if the property is not included, lots, it is a partial partition lots, it is liable to be dismissed. No plea was taken lots.
See, normally what happens that in a suit, all the properties are included for partition, and one of the defendant raises a plea that this property is my self-acquired property and therefore it should be kept out of partition.
But the deed defendant number one not admitting all the property. They said that it is not the property of the Lakshman Sharma. It is my property, Lord. Each and every paragraph.
They are not saying that. They are saying that this property, holding number 94, was acquired in the name of Lakshman Sharma. And this property having not been included in the schedule of property, therefore the suit is not making. Because the entire family of the joint family, the entire property of the joint family has not been included in the schedule of property filed by the plaintiff. That is their case. So if the plaintiff claims that it is his individual property, and therefore it was not included, because once that plea is raised, he has to justify as to why this property has not been included. And if he raises a plea that it is a self-acquired property and this property should not and rightly not been included in the schedule of property in the plain, then he has to prove that it is a self-acquired property.
No, it has to be proved by the defendant, Lord. According to section 101, Lord, you make and see section 101 of the Indian Evidence Act, Lord. I am reading. Make and see 101, Lord.
Who is asserting that it is? That's yes. There is no problem on this.
Lots of mechanism 106.
I just want to know, out of both the parties, who is asserting that it is a self-acquired property? The plaintiff or the defendant?
The defendant, Lord.
So, who is asserting that it is his self-acquired property? The plaintiff or the defendant?
Defendants.
No, defendant are not saying. Defendant are saying that
I am nothing saying about the holding number 94
right,
because it was purchased in the name of the Lakshman Sharma Lordship by virtue of registered sale from the Jagannath Sahu Lordship. Earlier Lordship there was lease between the Jagannath Sahu and Lakshman Sharma and one Parida Lordship, and subsequently Jagannath Sahu sold the land to the Lakshman Sharma, the original plaintiff Lordship. Lordship make 106 also Lordship of the Evidence Act. 106 also.
Yes, please.
Yes, burden of proving the fact specifically within the knowledge. When any fact is specifically within the knowledge of any person, then burden of proving this fact upon him. According to para 21 and 22 lordship, there is a specific statement of the defendant
So
that
therefore, the plaintiff is claiming that it is a self-acquired property.
I am not claiming.
You have not included it, no, in the schedule of
Why
property.
should I include property? Because it is a
No,
self-acquired
that's
property.
right. This is, you have not included it on the ground that it is your self-acquired
Self-acquired
property.
property.
Who is claiming that it is a self-acquired property? The plaintiff.
I am not claiming.
On
There is a statement.
There is a statement in the written statement. There is a statement that this particular property has not been included. It should have been included in the plain seeking partition, and it has been asserted that it is a joint family property. Correct? Right? That is why they want that it should have been included in the plain for partition.
Now the right? Can see judgment passed by the learned trial court. Issue claim by the learned trial court of para 5. Page 13.
Just a moment. Page number?
Page 13, lordship, para 5. The issue claim by the learned trial court.
Appellate court judgment?
No, learned trial court, lordship.
Page number?
Page number 13, lordship, para 5. The issue claim by the learned trial court.
आपका पेज नंबर इससे टैली नहीं
para 5, page number 13.
जस्ट अ मोमेंट, आपका पेज नंबर टैली नहीं करता, आपको पैरा नंबर
para 5 से क्या वाद जैसा कि रचित है विचार करने योग है, क्या वादी के पक्ष को वर्तमान वाद लाने के लिए वैध और विधिमान वाद हेतु हुआ है, क्या वादी का दावा परिसीमन विधि से बाधित है, क्या वादी का दावा विविध अतित्यापन एवं भारतीय के प्रावधानों से ग्रस्त है, क्या वाद पक्षकारों को असंयोजन के कारण बुरा है, क्या वाद आंशिक बंटवारे के कारण बुरा है, क्या वाद संपदा अर्जन मूलवादी लक्ष्मण शर्मा प्रतिवादी और मिलकर संयुक्त रूप से किया गया, इसमें दोनों पक्षों को आधा आधा हिस्सा है, या वादग्रस्त संपदा प्रतिवादी एक स्वर्जित संपदा, इसमें मूलवादी लक्ष्मण शर्मा को हकीकत अधिकार नहीं है, कि मार्च 1971 में रामचंद्र शर्मा लखन शर्मा के बीच कोई एग्रीमेंट हुआ, जिसके अनुसार वादग्रस्त संपदा में प्रतिवादी के हिस्से में पड़ी या पक्षकारों के बीच ग्रस्त संपदा में हकीकियत और कब्जा की एकता है, क्या वादी पक्ष मांगे गए अनुतोष पाने का अधिकार है, क्या वादी पक्ष को अनुतोष दिलाया जा सकता है। The findings of the वाद संख्या 6, there is a unity of title and possession with respect to the property. Para 6 words.
What was the finding in connection with each of the issues? Previous family arrangement के बारे में क्या finding?
हाँ. 4। para 40 lots. Para 40. Page 40 para 40.
The finding is at page para number 46.
Para number 46. उपयुक्त चर्चित इन दो दस्तावेजों के साक्ष्यों से उन्नत कराई परिस्थितियों इस न्यायालय में 1971 का फैमिली एग्रीमेंट विश्वसनीय लगने लगा है। यद्यपि इस न्यायालय के समक्ष कोई साक्ष्य जिसे लगे कि ये वाद पत्र के अनुसूची B/2 वाली जमीन कब बिक्री है, लेकिन ये मानते थे कि जमीन मौजूद 12D की थी और प्रतिवादी 5 से 12 इनके खरीदार। इस न्यायालय को ऐसा लगता है कि वर्ष 1971 के फैमिली एग्रीमेंट के बाद सही है और तभी वर्ष 1971 के पश्चात फैमिली एग्रीमेंट में मिली मौजूद गदरा की जमीन को लखन शर्मा ने पूर्व स्वामी के हैसियत श्रीमती मिश्रा को बेचा और मौजूद 12D का अनुसूची B/2 वाली जमीन को रामचंद्र शर्मा ने प्रतिवादी से 5 से 12 को बेचा। उसे फैमिली एग्रीमेंट के तहत लखन शर्मा की दुकान होल्डिंग नंबर 94 में दुकान करने लगे। उसी फैमिली एग्रीमेंट के तहत लखन शर्मा आरंभ होल्डिंग नंबर 94 में दुकान करने लगे और होल्डिंग नंबर 53 विवादित रामचंद्र शर्मा को मिला। 94 में तो हमको मिला ही है। इसी फैमिली एग्रीमेंट को मान लेने पर भी यह नहीं कहा जा सकता कि दोनों भाइयों को भी संयुक्त रूप से अर्जित की गई संपदा को मेड्स एंड बॉन्ड्स माप और सीमांकन देकर बंटवारा हुआ, क्योंकि फैमिली एग्रीमेंट को संपत्ति को बंटवारा का दर्जा नहीं मिल सकता है। गलत बोल रहे हैं फैमिली एग्रीमेंट को।
नहीं, अगर मान लीजिए आपका मीट्स एंड बाउंड्स से नहीं हुआ है और कोई फैमिली अरेंजमेंट ऐसा हो गया है कि आप इसको ले लीजिए और आप इसको ले लीजिए, दिस इज व्हाट इज सेइंग। फैमिली अरेंजमेंट में देयर हैज टू बी एन अरेंजमेंट बाय मीट्स एंड बाउंड्स ऑल्सो। इसमें कुछ एक प्रोपोर्शन ये सारी चीजें भी देखा जाता है। ऐसे फैमिली अरेंजमेंट को इस तरह से नहीं अपहोल्ड किया जाता है। दिस इज व्हाट द कोर्ट इज सेइंग। द कोर्ट इज एडमिटिंग that there has been a family arrangement, but saying that there has not been partition of means.
खैर बहरहाल ये न्यायालय सिर्फ उतना ही अभिमत प्रकट करता है कि मार्च 1971 में रामचंद्र शर्मा लखन शर्मा के बीच एक फैमिली एग्रीमेंट हुआ जिसके अनुसार वादग्रस्त संपत्ति अनियत प्रतिवादी वन के हिस्से में पड़ती थी। फिर भी यह नहीं कहा जा सकता कि यह संपत्ति माप और सीमांकन देकर बट गई है। और रामचंद्र शर्मा और लखन शर्मा के बीच हकीकत और कब्जा की एक यूनिटी एंड टाइटल्स पोजीशन चर्चा नहीं रहा। आज भी दोनों भाइयों के परिवार होल्डिंग नंबर 53 एक साथ रह रहे हैं। फलता न्यायालय यह अभिमत प्रकट करता है 1971 वाली फैमिली एग्रीमेंट के पश्चात पक्षकारों के बीच हकीकत और कब्जा की एकता इस प्रकार ये बात उत्तरित होता है। And 48 प्रतिवादी का कहना है कि मामला आंशिक बंटवारे के दोष से ग्रसित। उनका कहना है कि जब तक वाद होल्डिंग नंबर 94 साक्षी बाजार गदरा की जमीन है, तीसरा दास पोस्ट एंड टावर मिला की जमीन शामिल नहीं की, तब तक के बाद लाने के लायक नहीं। वादी कहना है गदरा की जमीन बिक चुका है, गदरा को ऑलरेडी बिक चुका है। होल्डिंग नंबर 94 इनकी स्वआर्जित संपदा है। रौलकेला तीसरा दादा पोस्ट की जमीन बिहार राज्य के बाहर है, इसलिए इस न्यायालय की क्षेत्रीय अधिकारिता में नहीं आता है। प्रतिवादी पक्ष की ओर से पक्षकारों की जन्मभूमि वाले गांव की जमीन समेत 5 रसीदें दाखिल जो प्रदेश L एवं L4 से अंकित है। ये रसीदें इस मामले में विवादग्रस्त तथ्यों को निपटारा के रिलेवेंट सुसंगत प्रतीत होता है। इस न्यायालय को ऐसा लगता है रिलेवेंट सुसंगत प्रतीत नहीं होता। इस न्यायालय को ऐसा लगता है दोनों भाइयों में से कोई भी स्वच्छ हृदय से नए मामले नहीं आया है। बिसरा और दादा पोस्ट की जमीन पैतृक संपत्ति लगती है जिसका बंटवारा बहुत पहले हो चुका। रौलकेला की जमीन के संबंध में न्यायालय के समक्ष कोई दस्तावेजी सबूत नहीं है, लेकिन होल्डिंग नंबर 94 के साक्षी बाजार गदरा की जमीन के संबंध इस न्यायालय में अभिमत प्रकट किया है कि दोनों भाइयों द्वारा संयुक्त रूप से अर्जित की गई है। गदरा की जमीन को इस बंटवारे में शामिल नहीं किए जाने के संबंध में वादी पक्ष ने अपने आवेदन में 20/5/1985 जो इसमें स्पष्टीकरण दिया है कि उस न्यायालय में गले नहीं उतरता। जब वाद संशोधित करने से पूर्व इस जमीन को बिक जाने के कारण बंटवारा के इस वाद में नहीं लाया गया, तो वाद पत्र के अनुसूची B/2 में उल्लेखित जमीन को इस बंटवारा में लाने और उसके क्रेताओं को पक्षकार बनाने की आवश्यकता है। दोनों संपदा संयुक्त रूप से अर्जित की गई और बंटवारे के मामले में दोनों संपदाओं को छोड़ देना चाहिए था। जब तक शामिल ही नहीं किया तो दोनों संपदाओं को शामिल कर देना चाहिए। बंटवारे के इस मामले में प्रतिवादी पक्ष भी होल्डिंग नंबर 94 और गदरा की जमीन को उचित या शुल्क देकर बंटवारे के जुड़वा सकते थे। ऐसा लगता है कि इन्होंने दोनों कारणों से नहीं किया। प्रथम एक इन्होंने सोचा हुआ कि मामला आंशिक बंटवारे के कारण बंटवारा हो तो मामला असफल नहीं होता, क्योंकि साम्य का नियम है कि बंटवारा हो तो सारी संपत्ति का बंटवारा हो, वाद बाहुल से बचा जा सके। चूंकि इस न्यायालय में इस वादी का आवेदन 20 मई 1989 के आधार पर होल्डिंग नंबर 94 गदरा के बंटवारे निर्णय पारित करने जा रहा है, इसलिए न्यायालय इस मामले में गदरी परिस्थितियों आंशिक बंटवारे दोष से ग्रस्त नहीं पाता होता है। न्यायालय अभी मत प्रकट करता है कि वाद वर्तमान वाद आंशिक बंटवारे के कारण बुरा नहीं रखा गया है। चूंकि इस वाद में गदरा वाली जमीन को भी बंटवारे के लिए निर्णय लिया जा रहा है, इसलिए आशंका है कि यह वाद पक्षकारों का असंयम के कारण बुरा हो सकता है। चूंकि मामला बंटवारा का है, न्यायालय गदरा और जमीन को वादी पक्ष के हिस्से में डालने का निर्देश दिया जा रहा है, इसलिए वादी के पक्ष खरीदार के हित पर कोई प्रतिकूल प्रभाव नहीं पड़ेगी। यदि खरीदारों को पक्षकार बनाए जाते इस मामले में और विलंब होता। साथ ही चूंकि उनके हित में प्रतिकूल कोई निर्णय नहीं लिया, इसलिए इस मामले में पक्षकार होना आवश्यक नहीं। इस प्रकार वादी के पक्ष में निर्णय हुआ। सुनवाई के क्रम में वाद समीक्षा को विवाद नहीं उठाया गया। सुनवाई क्रम में विरोधाओं की कोई दबाव नहीं डाला गया है। पूर्व में विरोधाकों को विनिश्चित क्रम इस न्यायालय ने यह अभिमत प्रकट किया कि वादग्रस्त संपदा होल्डिंग नंबर 94 गदा की जमीन रामचंद्र शर्मा लक्ष्मण संयुक्त अर्जित संपदा है, जिसमें दोनों भाइयों का आधा हिस्सा है। अभिलेख पर उपलब्ध साक्ष्य से प्रमाणित होता है दोनों भाई जो एक समय सब कुछ संयुक्त रूप से अर्जित किए थे, आज समय ऐसा बदलाव ला दिया है कि कुछ भी नहीं रखना चाहते। ऐसे पूरे वादी के पक्ष को बंटवारा के लिए वर्तमानवाद लाने के विधि मानवाद हेतु और मांगे की अगति पाने का हकदार है। न्यायालय अभिमत प्रकट करता है कि वादी को वाद पत्र की अनुसूची A, B, 2 तथा C में संपदा में 1/2 हिस्सा था, अनुसूची B और संपदा में 1/8 हिस्सा है। साथ ही न्यायालय अभिमत प्रकट करता है कि होल्डिंग नंबर 94 मौजा गदरा की जमीन जिसका उल्लेख प्रदेश A4 में किया गया है, वादी प्रति आधा हिस्सा, इसको आधा बांट दिया है। होल्डिंग नंबर 94 को भी आधा बांट दिया। इस बात को प्रतिवादी से साधोरित होता है तथा अन्य प्रतिवादी को निर्वित जयपत्रित किया जाता है। वाद परिस्थितियों को पक्षकार अपने and the findings of the learned appellate court also, कारण 9.
Yes. See, the family arrangement of the year 1971, by which allocation was made, has not been disbelieved by the court. The court says that there has been a family arrangement, that this property will be given to the plaintiff, but there has been no partition of the principal.
Therefore, the holding number 94 came in the share of the Lakshman Sharma.
By virtue of the family arrangement.
Family arrangement.
By virtue of the
family arrangement.
Right?
Yes.
So therefore, this particular property, even if it comes to the share of Jharkhand Sharma by virtue of family arrangement, So if the properties are to be divided half and half, then under such circumstances, this particular property as per the family arrangement will fall to his share. Simple.
No. No.
You see, now there are 10 properties in the schedule of the claim. Now 11th property will also get joined, and then when the properties are to be distributed half and half, then one property can fall in the share of entirely can fall in the form.
Holding
It
number.
is not necessary that
the entire holding number came into share of the Lakshman Sharma Lords. There is a finding of the London Trial Court Lords.
by virtue of family arrangement.
Family arrangement.
But the family arrangement was not by means and bounds. That is also a finding. Therefore, there is no finding that there was a previous partition. If there was a previous partition, there was no question of fresh partition. Then the suit should have failed outright. But since there was a family arrangement, that this property will, as per the family arrangement, will fall in the share of the plaintiff, right? And then when the plaintiff is seeking partition of the property, firstly he has not disclosed about the family arrangement. He is completely silent about the family arrangement. He got that property in family arrangement, and then he filed a suit for partition. In the written statement that family arrangement has come in light, the court has believed that there was a family arrangement, right? And has held that there was no partition by means of.
But that's
So therefore, this property, since there is no finding that there was a previous partition, it was just a family. There is no finding that there was a previous partition. So this property has also to be included.
no. Lord say, therefore, Lord say, after the 1971 family arrangement, Lord say, some of the property was sold by the Lakshman Sharma
Yes,
as well as the defendant number one, Lord say.
So those properties which have been sold,
Therefore, he
they fall in their allotments.
cannot disbelieve the family arrangement, Lord say.
That is not a substantial question of law. I will not go into that. Why should I go into that? That is not a substantial question of law.
I am relying on 1-2 judgment also, Lord.
Now let us see the appellate court side.
Yes.
And show me 1-2 judgment, whatever you want to apply for.
Yes, appellate court judgment.
No, those judgments first, let me see that. Those judgments, 2 judgments.
Variety, Lord say.
Yes.
Yes. The legal principle therefore is that there is no presumption of the property being joint family property, only account the existence of the joint family, Hindu family. One who asserts has to prove the property is a joint property, Lord. Asserts by who? By the defendants. I am not asserting. I am not saying that that the holding number is the joint family or the self-acquired property. It has to be proved by the defendants. It was purchased by the joint fund of the plaintiff and defendant number one, Lord.
We say that the property was purchased by selling of a property.
Silly?
By selling of holding some shop number 5. Shop number 5 was sold.
Holding number 94. Holding number 94.
Holding number 94 was purchased by selling shop number 5.
But there is no evidence, no documentary evidence.
We'll see that.
There is yes. The legal principle therefore that there is no presumption of the property being joint family property only on the account of existence of the joint Hindu family. One who asserts has to prove the property is a joint family property. If, however, the person so asserting proves that there was a nucleus with which the joint family property could be acquired, there would be presumption of the property being joint, and onus would shift on the person who claimed to be self-acquired property to prove that he purchased the property with his own funds, not out of the joint family nucleus there was a available lordship. But there is no evidence lordship it was purchased by the joint.
He has disclosed that how it was purchased.
Only mere statement is not enough. It has to be proved by the evidence or documentary evidence lordship. There is no evidence that it was purchased by the joint family property. There is only presumption.
Is there any evidence that there was a difference? Because there was a joint family business.
I will see the.
There was a joint family business, it is not in doubt, because they were running the shop. And this particular shop only.
The shop was run by the plaintiff also, not by the defendant number one.
Maybe, but it was a joint family business. Somebody has to sit in the shop, isn't it? Yeah, let us see the appellate court statute. The family first joint cannot be disputed. The reason being that the plaintiff himself is claiming partition. So he cannot dispute that the family was not joint.
With respect to other property, not
That's
the
right.
holding number 94.
That's right. That's right.
Why?
Just a moment, one by one. First step is whether the family was joint or distinct.
It is a joint property with respect to other property except
Please
the
don't
holding.
segregate the property. In a family,
I will
in a partition suit,
segregate.
you will for the facts, but in a suit for partition, the first thing is that there has to be a joint family.
With respect to other property, not the holding
Please
number 94.
Don't jump to the facts of this case. In a suit for partition, the first question is whether there is a joint family, existing joint family. So, since you are claiming partition, you cannot say that there is no joint family. The second step is...
I am saying joint property with respect to only scheduled landlords.
That's right.
Not the holding number 94.
That's right. Out of the various properties which you have included, you say that these are the properties which are subject matter of partition. Now, the defendant says that one more property has been wrongly not included. And there are many other properties also with which there is no evidence, but we are not concerned with that. And they also say that it was purchased by selling of the property. They also say so. Now, if the defendant is able to establish a nucleus in the joint family, then the onus will shift upon the person who claims that it is his self-acquired. That is the judgment you have said.
But the defendant has failed to prove that whether it is a joint family fund or not, Lordship.
That's right. We'll see that.
Page 10, Lordship.
Where is the point for determination?
I think that there is no point for determination.
Para 9 se padi.
The court accepting the jointness of the plaintiff and defendant number 1 declared the suit also directed the partition of holding number 94 of the Sakshi market in land of Gadra is equal share along with other suit property on the basis of the material available on the record. The respondent number 1 to 7 by putting their appearing filed cross objection which was later on admitted in cross objection appeal for convenience numbered as the original number of the appeal was 34/1987. They have put their cross objection in respect of issue number Cha and Ja, which was in respect of holding number 94 of the Sakshi market, standing in the name of Lakshman Sharma. The original plaintiff, the respondent has said that.
No, why? Carry on, please. The respondent has said that.
The respondent has said that impugn judgment only to the extent in which the unity of title in possession in respect of holding number 1994 and said situated as Gadra were accepted by the lower court in order to partition the land among the plaintiff and defendant number 1. And the pleading of the party altogether.
Yeah, what was their grievance? This property they wanted to be included, it was included. Why were they agreed? Why did they file a cross appeal?
Cross appeal was filed by me, Lordship, before the first appellate court, Lordship.
Who was the appellant?
Appellant was the defendant number 1. It is not liable to be partitioned. Appeal was filed by the defendant number 1 and cross objection was filed by the plaintiff.
Okay. All right. Please carry on.
On the pleading of the parties, altogether 8 issues were laid out of the other are ceremonial issue. The main issue were issue number Cha and Ja, and they were as here under. whether the suit property was acquired the plaintiff and defendant number one jointly half share each, and it was self-acquired property of the defendant number one having no right title interest of the principal plaintiff Lakshman Sharma. As to whether there was any family arrangement between the plaintiff Lakshman Sharma and defendant number Ramchandra Ram in respect to suit property in the year 1971, and the suit property fallen in the share of the defendant number one, and he was in possession of the suit property having all the right title interest. Finding this issue is the main issue to be decided in the suit. If it is decided the suit property was the self-acquired property of the defendant number one, Ramchandra Sharma, then the plaintiff respondent has no case of the parties. The appellant has asserted that impugn order on the ground that court has failed to appreciate both the oral and documentary evidence available in the report in which he has proved that the suit property was the self-acquired property of the defendant number one, Ramchandra Sharma. It was the case of the defendant that came from the United Place in the year 1988, 38, 1939. After getting the partition of the ancestral property of the Odisha for which a suit was filed in the court of Munshi, Bahrampur, Odisha, then the documents concerned were burnt in fire. To avoid the procurement of the documents of the partition, the respective party entered in memorandum of partition dated 5/3/1966, having the signature of the shareholders, defendant number Ramchandra Sharma and deceased plaintiff Lakshman Sharma, which was exhibited Exhibit C, although it was objected by the plaintiff that the signature of Lakshman Sharma is forged. The court below has accepted the fact that there was a partition between the co-sharer of the sons of Jagbandhu Patra, who was the common ancestor of the plaintiff and respondent number 1 and 2. In the light of the exhibits, it is clear there was a partition of the ancestral property between the parties. The further case of the appellant is that after coming from the native place, the plaintiff started a grocery store on holding number 0.53 Andi line, taking on the rent, and business of the appellant flourished. Then in the year 1946, he brought the present plaintiff, who was the student of the school in Puri, to help him in other work. It has been argued by the learned counsel for the defendant number one that it is proved that the grocery shop was exclusively belonged to the defendant number one. Then it will be clear that such property was acquired from the income of said grocery shop, and it was the self-acquired property of the defendant number one. It is requires no partition because said grocery shop, and it is the self-acquired property of the defendant number one, and it requires no partition because the said grocery shop cannot be said to be established with the common fund of the plaintiff and defendant. In support of this contestant, he has relied Exhibit H and Certificate of Registration under Section 9 of the Bihar Sales Tax Act 1959 from the 5 which stands in his name, registration certificate dated 24/9/1955 under the Bihar Shops and Establishment Act 1953. Exhibit F, according to defendant number one, had the schedule A property belong to the plaintiff, it must be named in those documents. On the contrary, it stands in the sole name of the Ramchandra Sharma. The further case of the defendant is that accordingly rent were paid to the original landlord Madhab Sahu for Exhibit A and Exhibit A by 1 had been produced for consideration. He also supported that schedule A property was the self-acquired property of the defendant number one. Although the sale deed stands in the joint name of the plaintiff Lakshman Sharma and defendant's number Ramchandra Sharma, the defendant Lakshman Sharma, owner of the property, the name of the defendant is the
So where are you getting it is standing in the joint name? Joint name में तो नहीं है.
नहीं इतना प्रॉपर्टी सबके जॉइंट नेम में है.
नहीं ये वाला जो एग्जिबिट आप दिखा ये तो जॉइंट नेम में
नहीं जॉइंट नेम में नहीं है. तो जॉइंट नेम में नहीं है. जो होल्डिंग नंबर 94 के बारे में बोल रहे हैं. हाँ तो जॉइंट नेम में नहीं है.
ठीक है आगे बढ़िए.
The rent receipt of the holding number 53 of schedule A property also stand in the sale of defendant number 1. Exhibit E to E by 19, Exhibit E by 22, and the rent receipt and explanation has been advanced about the non-production of the original salary by the defendant number 1 through PW2 Srinivas Sharma, having power of attorney in behalf of Ramchandra Sharma, that in the year 1972, when the zamindari of the Tata company was vested in the state of Bihar, as per the Registration Act, a notice was issued by the collector in the month of February 1973 for taking settlement of schedule A property as fixed fixed date 1/28/1973 in the name of Ramchandra Sharma. Exhibit J, in pursuant to that the notice, the original schedule of cellular property was handed over to the property Lakshmana Sharma, who used to see out the work of producing the original schedule before the collector when he did not return to the defendant number 1. Only a photocopy was kept with the defendant number 1. By putting these documents, the appellant or the defendant wanted to impress upon these documents that these were the document before the court below to come to the conclusion that Schedule A property was the said property of the defendant number 1 and the plaintiff was named landlord only. The further case of the plaintiff defendant is in respect to Schedule B that it was acquired only about year 1948 in the title suit number 14 of 52. The vote is right title interest has been confirmed by the court of subordinate judge Jamshedpur. The certified copy of the said order has been exhibited as exhibit and this suit was ended in compromise and in respect of Moja Barindi, Khata number 17, Khesara number so and so, Ramchandra's house, it has been emphasized by the appellant defendant that had the plaintiff any right title interest, he must have been necessarily party or put any objection to the effect or be a party to the compromise. In respect of the property detailed in Schedule B by 1, the case of the appellant defendant is that it is also self-acquired property. In support with contention, you filed a Rayati Parcha which was exhibited 0/1, except that no document is brought on the record. With regard to the property of the Schedule B, it is the case of the appellant defendant that it was acquired in the year 1945. His right title interest possession is confirmed by title suit number 862 of 1964, which was instituted by Ramchandra Sharma against the Narayan Puj in others. The suit was in respect to RS Khata number 18, RS Party plot number 3887, area 67 DC. The order court exhibited exhibit in by the plaintiff has filed one purchase of the rent survey standing in his name exhibit for having no signature of any officer or seal of the office. So far as Schedule C property is concerned, which is the case of the appellant defendant, the required land from the original area by the registered sale dated 3/1/1956, which was exhibited at exhibit 1 along with the defendant number 12 and 13. Thereafter, more of the case of the appellant defendant is that in present survey khata, those lands was recorded as Jahanabad, Bihar Sarkar, Dimas for illegal possession of the defendant number 1, 12 and 13 along with Lakshman enter. The certified copy Khatiyan is marked as exhibit 11. It has been stated on behalf of the defendant that the defendant 1, 12 and 13 filed an objection hearing case number so and so before the assistant settlement officer who filed his order dated 14/11/1984 deleted the name of the Lakshman Sharma. The said order is exhibit C. This shows that the plaintiff respondent has both no right title interest over the land written in the Schedule C, as he did not prefer any appeal against that order. The appellant defendant has also tried to substantiate his case through the oral argument. On the other hand, the case of the respondent plaintiff has tried to bring on the record that in the year 1945, he along with his brother Ramchandra Sharma came from the native place to Jamshedpur, started a grocery shop in the Schedule A property, which was ultimately purchased in the joint names from the income of the grocery shop number 27/6/1965, Exhibit 3. It has been submitted on behalf of the respondent that when the very recital that it will appear that 20 years before the execution of the said deed purchase came in possession as a tenant, which confirmed that defendant number 1 had not come in the year 1988, 38, 13, rather in the year 1941. No receipt prior to 1940 has been brought on the record by the defendant. The sale stands in the joint name by the mutation could not be made as a superior landlord so has not permitted mutation in the joint name as per the custom. This fact is also incorporated in the very recital of the said deed exhibit 3. The sale deed bear the signature of the plaintiff and respondent Lakshman Sharma and defendant number 1 Ramchandra Sharma. It shows that they were aware about the contents of the deed. The further case of the plaintiff, the explanation given by the defendant is for the position is a lame excuse which will appear from the fact that if it is presumed about the existence of the family holding on 16/3/1971 and Schedule A property is coming in favor of the defendant, then it was essential on the part of the plaintiff to hand over the said exhibit 3 in possession of the defendant. Ramchandra Sharma. In event in the year 1970, there was no question to hand it over again for taking a stay resettlement of the collector of the case of the plaintiff responding is that Schedule B property is that purchased with joint and having 3 by 4 share of the not and by 4 share of the plaintiff in defendant. The whole case of the defendant bound to be demolished from the Exhibit 7. The certified copy of the petition dated 19/12/1973 filed in the Court of Settlement of the Jamshedpur case number so and so filed by Ramchandra where he admitted that fact that the grocery shop was the joint property of both the parties and from the joint income of the said grocery business. The other suit property were also purchased by both the property in respect to business of grocery. And both the brother in Schedule A and Schedule 2 in their joint application admitted their joint possession. In one state application in Schedule 2, their description of the land finding place in the Schedule B land of the plaintiff. In Schedule A, description of the land as mentioned in the Schedule B by another land. The petition by which so admission has been made will come as a estoppel against the defendant to make the further case of the self-authority. No explanation has been brought by the defendant with regard to Exhibit 7. So far, the suit line detail in Schedule B is concerned. In the original plaintiff, Lakshman Sharma was found by filing petition. It was deleted on the ground that there was no need in his name. This showed that there was a huge property purchased from the joint name of the grocery shop in Jamshedpur adjacent area. It has been further contended that defendant responded about Exhibit 1 by the notice sent to the Lakshman Sharma through the Land Council of Sri Ramchandra Sharma on 26/1983, Assessment Act 83. In said notice, it was admitted that from the joint income of the grocery shop property were acquired in the Jamshedpur adjacent area in Mango and Royal in respective of in whose the case is claimed. The further case of the plaintiff respondent the petition under section 140 CRP bearing case number 7 Exhibit 92 will appear that with the application of the appellant the holding number 53 has been acquired by them in joint fund having other joint property in Mango, Baradi, Jamshedpur, and the state of India. I have gone through the impugn order and the document referred by the party from the case of it is clear that it is not the case of the division of the personal property, possession of the common interest, but it is the case of reunion of the party. I am in view that the court will very carefully examine all these facts and come to the conclusion relying on the Exhibit 3, Exhibit 7, Exhibit 9. There is no dispute about the reunion of the plaintiff respondent and defendant movement. An appellate after coming from their native place to Jamshedpur started a grocery business in the holding number 53. The income of the grocery business flourished and other suit property. Schedule B, B by 1, B by 2 and C were purchased from the collective fund of the party. I mean the concurrent view that finding the court below on account is based on the sound principle of law as well as factual and oral agreement hold that suit property was purchased by the joint fund of the both the parties having equal irrespective of the fact instead in whose name. The court will act further on the basis of the pleading the defendant has come to the conclusion holding number 94 situated in Sakshi and land of Moja whether I stand in the name of the plaintiff also part of the joint funding fund raised in grocery shop. This is the reason of filing the cross appeal according to appellant of the cross appeal Lakshman Sharma. It was the same about property which was purchased from his own income but court has erroneously incorporated his land which were not the suit property and finding place in the description of the suit property in schedule without any rhyme in reason. According to cross appellant, the court has got no jurisdiction to make any order of the partition over the suit land which was not the suit property. According to him, it was the case of the reunion of the party and not the division of the interests of the party. So every property cannot be put for division. Therefore, impugn order is likely to be set aside to the settlement. On the other hand, the case of the defendant very beginning is that the cross appellate has not come with a clean hand demanding any partition of the property which was required by Ramchandra Sharma from the grocery shop. The defendant in his written statement very clearly has mentioned these facts and stated the plaintiff purposely concealed the fact that holding number 94 of the Sakshi Bazaar land of Moja Gadra which was sold to someone taking it to be exclusively devoted to number 1 that stated due to family arrangement in the year 1971 has scheduled along with the other property detail were put in his share holding 194 land of Gadra and other in Odisha 3.75 come into the share of the community and not brought this fact and therefore denied the family arrangement. It is not the case of the community before the court ruled that he acquired the holding in 1994 land of mother father individual income. On other hand, again after the creating of the dependent Ramchandra for before therefore no claiming to be brought on the equity. The second is that if a fact is not denied in the creating is there is
That's right, you have read it. Now, sum of your submission, you are relying upon this judgment.
Yes.
Any other judgment?
No. And section 101 and 106 of the evidence.
Or the learned counsel opinion on behalf of the applicant. Sole appellant.
There are various arguments.
On behalf of the applicants. Nobody appears on behalf of the respondents. This appeal has been filed against the judgment and decree dated 24/5/2002, within bracket, decree signed on 7/6/2002, bracket closed, passed by learned additional district judge Singhum, within bracket East Jamshedpur, in title appeal number 34 of 1987, dismissing the cross appeal filed by the plaintiffs in the same appeal and confirming the judgment and decree dated 27/5/1987/12/6/1987, passed by learned sub-judge Woman 3 Jamshedpur in title suit number 65 of 1975, in title suit number 65/75 of 1985-86. The records reveal that the original plaintiff was Lakshman Sharma, and the defendant number one was his full brother, namely Ramchandra Sharma.
Cross objection filed against the High Court, which was dismissed for default on 8/9/2022. Cross objection संख्या 3 of 2022.
Cross objection number
3 of 2022.
3/20.
Which was dismissed for default on 8/9/2022.
The learned counsel for the appellant. The first appeal was filed by the legal heirs and successors of Lakshman Sharma.
Yeah, first appeal was
First
filed by the
appeal to
defendant number 1.
Achha.
Defendant number 1. In
The
cross
first
petition
appeal.
filed by the plaintiff.
The suit was decreed and half share of the plaintiff and defendant number 1 was declared.
No. What to make an receipt? The judgment.
कितना share दिया था?
वही बताना सर. Judgment of the learned trial court. Para 57 notes. The learned thing trial court. सबका अलग अलग दिया हुआ है.
अच्छा. जितने बाकी defendants थे, they are all the family members or they
Some
are
are
the
the
purchasers?
other person also. Main contesting the defendant number 1. Ramchandra Singh.
The counsel for the appellant has submitted that the main contesting defendant was defendant number 1 and other defendants were
Others also the family members also.
were also the family members.
And 12 and 13 are the performer respondents.
And defendant number 12 and 13 were the performer
Respondents.
defendants. The learned counsel submits that the substantial question of law framed in this case revolves around holding number 94. He submits that holding number 94 was not included in the schedule of the plaint, but the learned trial court had included holding number 94 while passing the decree for partition of the property.
आप से आप holding number 94 also.
By passing the decree regarding the partition of the property and half share each with respect to holding number 94 was allotted to the plaintiff and the defendant number 1. The learned counsel submits that on account of inclusion of holding number 94 in the partition, though in the partition at the instance of the defendant number 1, the plaintiff had filed cross objection / cross appeal before the learned first appellate court. The defendant had also filed his appeal, had filed the appeal before the learned first appellate court, who was agreed by the order of partition. He submits that the cross objection as well as the appeal of the defendant number 1 before the learned first appellate court as well as the cross objection were dismissed by the learned first appellate court Consequently, the plaintiffs have filed a second appeal, and the legal heir and the defendant number 1 slash their legal heirs had also filed cross objection number 3 of 2022, which stood dismissed by order dated 8/9/2022. The order of dismissal was on account of default in removing the defense.
Did not appear non-prosecution on account of non-prosecution.
The learned counsel then referred to the substantial question of law framed in this case by the order dated 21/4/2005, which is quoted as under. The learned counsel submits that holding number 94 was standing in the name of the plaintiff.
Original plaintiff, namely Lakshman Sharma.
Original plaintiff, namely Lakshman Sharma, and since it was his self-acquired property, it was not included in the schedule of the
Yes.
He submits that the defendant in their written statement
Para 21 and 22.
had asserted in paragraph 21 and 22. Defendant number 1, इसका defendant number 1 in their written statement. In paragraph 21 and 22 had asserted that Lakshman Sharma had not whispered a word with respect to holding number 94, which was once acquired by defendant in the name of K. Mahapatra, nephew of the defendant number 1, within brackets, son of his elder brother, namely Markandeya Patro, that it was. And subsequently, it was acquired in the name of the original plaintiff. By virtue of registered sale deed dated registered sale deed
In the year 1968.
registered sale deed dated 12/8/1968. In paragraph 22, it has been asserted that the property was acquired in the name of Lakshman Sharma, the original plaintiff, after collecting some money by selling another shop at Baridi Jamshedpur, being shop number 5. The learned counsel has then referred to paragraph 26 of the written statement filed by defendant number 1, that that it was alleged that the original plaintiff has suppressed many facts and have not included some considerable amount of property, like holding number 94, which was acquired in the joint names of the parties, and it was asserted that unless the same is included, the suit cannot proceed. The learned counsel submits that the plaintiff did not include holding number 94 as a suit property, and it was the defendant number 1 who asserted that holding number 94 was joint property. So it was the onus of the defendant number 1 to prove that the property was the joint property of the plaintiff and the defendant number 1.
What's the cross number I have normally given? Cross provision number 3 of 2005.
Cross objection number 3 of 2005. The learned counsel has submitted that the property in holding number 94 was standing in the exclusive name of the original plaintiff, and it was the defendant number 1 who asserted that it was the joint property. Therefore, it was for the defendant number 1 to prove this fact by bringing on record holding evidence. He submits that in absence of some such holding evidence, the learned courts could not have included holding number 94 for the purposes of partition of the property.
Property of holding number 94.
Partition of it could not have included holding number 94 for the purposes of partition. The learned counsel submits that so far as the direction for partition in connection with the other properties are concerned, the plaintiff has no grievance, as the suit stands decreed in favor of the plaintiff.
The same was confirmed by the first appellate court.
It was confirmed by the first appellate court, and the cross objection filed by the defendant in this particular case
The cross objection filed by the
defendant,
plaintiff,
and the cross objection filed by the defendant in connection in his cross objection number 3 of 2005 has been dismissed. The learned counsel has referred to Exhibit 6/9, which was the lease between Jagbandu Sahu on one part and Lakshman Sharma and Surendra Nath Palida on the other part. And the lease deed was dated 18/12/1962. Thereafter, he referred to Exhibit 6 and 6/A, which is dated 12/8/1968, to submit that the holding number 94 was purchased exclusively in the name of Lakshman Sharma and not jointly in the name of Lakshman Sharma and dependent number 1. The Learned Council has submitted that the Learned Council has also referred to section 101 and 106 of the Indian Evidence Act to submit that the onus was heavy on the onus was on the dependent number 1 to prove that the property was acquired jointly
With respect to the holding number
with
94.
respect to holding number 94.
It was purchased in the joint family fund of the plaintiff and defendant number 1.
He has also submitted that it was also for the dependent number 1 to prove that the property was purchased from joint family fund. To plead and prove that the property was purchased from joint family fund. The Learned Council has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2003, bracket close 10, SCC 310, and has referred to paragraph 18 thereof, which reads as under quote beneath. The legal principle, therefore, is that there is no presumption of the property being joint family property only on account of existence of a joint family. The one who asserts has to prove that the property is a joint family property. If, however, the person so asserting proves that there was a nucleus with which the joint family property could be acquired, there would be presumption of the property being joint, and the owners would shift on the person who claims it to be self-acquired property to prove that he purchased the property with his own funds and not out of joint family nucleus that was made. The Learned Council submits that if the aforesaid principle of law as laid down by the Honorable Supreme Court is followed, then the defendant number 1 has miserably failed to prove that holding number 94 was a joint family property, and therefore the learned courts have wrongly included holding number 94 in by partitioning the property, although admittedly holding number 94 did not form a part of the schedule of the plain seeking partition. इसको हाफ एंड हाफ क्यों किया है, बाकी को तो हाफ एंड हाफ नहीं किया?
नहीं, बाकी सबका अलग अलग इसमें दिया गया है 57 में, उसमें कोई डिस्प्यूट नहीं है।
नहीं, हम जानना चाहते हैं
57 में वो देखा जाए
कि हाफ एंड हाफ क्यों दिया?
एक आरंभिक अभिव्यक्ति तैयार की जाए जिसमें वाद पत्र की अनुसूची ए, बी, B/1, B2, C तथा साक्षी बजाय के होल्डिंग नंबर 94 इन गदरा के जमीन वादी का आधा हिस्सा, प्रतिवादी दोनों का आधा हिस्सा तथा अनुसूची बी की संपत्ति वादी का 1/8 हिस्सा, प्रतिवादी का 1/8 हिस्सा दर्शाया गया है। कालक्रम में वादी का आवेदन व सर्व जानकार अधिवक्ता आयुक्त की नियुक्ति की जाए। बाकी में 1/8 कर दिए गए।
1/8 के सूत्र ये 1/8 शेयर ही मांगा।
वही मांगा दिया।
रघुनाथ साहू कौन है? Who is this रघुनाथ साहू? Is he a relative? Raghunath Sahu is a third party. फादर का नाम भी टैली नहीं करता।
नहीं, फादर नाम भी टैली नहीं करता।
एकदम नहीं टैली। ठीक है, बस हो गया आपका?
जी। पारा 24 में इसका दिया होगा ट्रायल कोर्ट जजमेंट नोट्स।
पारा 24
ऑफ द ट्रायल कोर्ट जजमेंट। वादी से करना है अनुसूची बी वाली जमीन लक्ष्मण शर्मा ने रामचंद्र शर्मा तथा रघुनाथ शर्मा के साथ संयुक्त रूप से खरीदी है, इसलिए उनको दिया गया है।
They joined it, but he is a third party. He is not a family member.
नहीं, not the family member.
Okay. Title Democratic Partition Suit number 65 of 1985-86. 65/75 of 1985-86 was filed by Lakshman Sharma. Seeking partition of properties mentioned in schedule
para 15 minutes plaint.
for the following relief para 15 of the plaint proposal. The specific case of the plaintiff was it is not in dispute that defendant number 1, that the plaintiff and defendant number 1 are full brothers, and they were originally resident of Orissa. It was the specific case of the plaintiff that the plaintiff and defendant number 1 came from Orissa to Jamshedpur and they jointly started grocery business in the ground floor of holding number 0.53, and the entire building was taken on rent from one Madhav Sahu, the owner of the building. The plaintiff and defendant number one jointly carried on their business, each having half share in the business, and from the earning of the business, joint business, they purchased two-story building from the owner Madhav Sahu and his son Vishnath Sahu by registered sale deed dated 27/7/1965 for a consideration amount of ₹6,000. And the sale deed was executed by Madhav Sahu and his son in favor of the plaintiff and the defendant. It was their case that the building was purchased by them out of their joint family fund, that is, income from the joint family grocery business and the said building purchased by registered sale deed dated 27/7/1965 was described in Schedule A of the plate. It was their further case that after purchase of the building, the same was mutated only in the name of defendant number one, as according to the rules of the company, the holding is to be mutated in name of only one person. It was the further case of the plaintiff that the plaintiff and the defendant number one were in joint possession and they were residing in the building along with their family members, and the plaintiff had half share. Plaintiff and defendant number one each had half share, and they were separate in mess. It was the further case of the plaintiff that out of the joint family fund, the plaintiff and defendant number one purchased another property detailed in Schedule B jointly with Raghunath Sahu, in that way defendant number two. And after purchasing the same, they jointly undertook construction over the property with Raghunath Sahu, and they were in joint possession with Raghunath Sahu. The property was purchased out of the fund from the deposit business. Accordingly, it was case of the plaintiff that Raghunath Sahu has 3/4 share on the Schedule B property, and the plaintiff and the defendant number one jointly have 1/4 share in the deposit property. And thus the plaintiff has 1/8 share and the defendant has 1/8 share, and Raghunath Sahu has 3/4 share with respect to Schedule B property. Further property, as per the claim, further property was purchased from the joint business and joint fund by the plaintiff and the defendant number one, and which was mentioned in Schedule C of the plate, and in the recent survey a portion of the property along with a small house thereon has been allotted to the share of the plaintiff and defendant number one, and they are in joint possession of Schedule C property, each having half share. The plaintiff asserted that for proper adjudication of the suit, Shatrughan Sao and Ramlal Maji were made pro forma defendant in the suit. It was also asserted that the defendant number one had confiscated 40 certain immovable property in terms of gold, etc. It was a further case of the plaintiff that though the plaintiff and defendant number one were separated in mess, but have separated in mess, and their joint grocery business has been closed in or about the year 1978. Though the fair price shop is still running in Schedule A of the property. It was the further case of the plaintiff that the defendant number one has sold some of the joint properties and the plaintiff requested for amicable partition, which was refused, which gave rise to the cause of action by the partition suit. It was for the case of the plaintiff that the defendant and plaintiff number one had purchased further properties mentioned in Schedule B within bracket Roman 1 and also in Schedule B within bracket Roman 2. It was asserted that the defendant number one had sold land to defendant number 5 to 12 by 8 separate sales, and that the plaintiff and defendant number one It was also asserted by the plaintiff that the plaintiff and the defendant number 1 with their joint family fund acquired some land in Moza Mando jointly with Shatrughn Sahu, defendant number 3, and Ramlal Manji, defendant number 13. And after purchase, the plaintiff and the defendant number 1 jointly with Shatrughn Sahu and Ramlal Manji constructed some house in their postal land. And subsequently, there has been amicable partition on their postal land, and a house thereof has been constructed. The plaintiff claimed half share in the properties described in Schedule A and C, and 1/8 share in the property described in Schedule B. And half share of property described in Schedule B within bracket Roman 1 and B within bracket Roman 2. The records reveal that separate written statement was filed by defendant number 12 and defendant number 1. The defendant number 1 opposed the suit by asserting that the suit itself was not maintainable and there was no unity of title and possession in all the suit properties between the parties. The case of the plaintiff, it was asserted that it was false to allege that the defendant number 1 and Lakshman Sharma had come to Jamshedpur and that they jointly started a grocery business in holding number 58 as alleged by the plaintiff. The defendant asserted that they came in Jamshedpur, that the father of the defendant and the plaintiff number 1 came in Jamshedpur in the year 1938. Yes, it was the case of the defendant number 1 that he came to Jamshedpur alone in the year 1938 after death of his father in search of livelihood and took the entire holding number 53 described in Schedule A of the plate as tenant on monthly rent and started a business of grocery shop from his own and separate fund. And was residing in his family in a portion of the same. The house was originally a single-story building which was subsequently constructed to 2 units. was further case that in the year 1946/47, since the business was flourishing, the defendant number one asked his brother Lakshman Sharma, who was a student at that point of time, to come to Jamshedpur and for getting help in his outdoor business. The defendant number one also used to maintain the family of Lakshman Sharma to be that original plaintiff that it was. During this period, the defendant number one acquired landed property in plot number 352 and 351 in the joint name of the plaintiff and the defendant number one by registered deed dated 23/7/1951, and further acquired property in old plot number 352 in the joint name of the defendant number one and Lakshman Sharma, the plaintiff. It was the case of the defendant number one that he was occupying portion of Schedule A property as tenant out of his, which was purchased by the defendant number one out of his self-acquired fund, though in the joint name of defendant number one and Lakshman and the plaintiff from the rightful owner by registered deed of sale dated 27/7/1965. It was the case that the defendant number one, having purchased the Schedule A property out of his self-acquired fund, unconcerned with Lakshman Sharma, the name of defendant number one was duly mutated in the office of Messrs. Disco, exclusively in the name of defendant number one, and the defendant number one continued to pay rent to Disco. It was their case that the plaintiffs, the original plaintiff was never the owner of the suit property mentioned in Schedule A of the plaintiff, and the original plaintiff was merely a name lender The further case of the defendant was, the defendant number one was that the father of the defendant, namely Jagbandhu Sharma, and his sons were members of a joint Hindu family governed by Mitakshara School of Hindu law, and they had ancestral property in Odisha. And the suit was for partition was brought 55 years back, which and there was a partition with agreement. It was their further case that the plaintiff are not in joint possession of the property, and they have no share with respect to the same. In connection with Schedule B property, it was asserted that the same exclusively belonged to the defendant number 1 and his other co-sharer, namely Raghunath Sav, which both of them had acquired in the year 1948 and got their title and possession confirmed in a decree in title suit number 14 of 1962. It was asserted that all the structures in Schedule B property was constructed by defendant number 1 and Raghunath Sav. And it was their exclusive property, and the plaintiff has no right with respect to Schedule B property. The case of the defendant number 1 with respect to Schedule C property was that the land in Schedule C property and structures standing thereon belonged to a separate property of the defendant number 1 and defendant number 12 and 13, who purchased the same for valuable consideration from the previous owner by virtue of registered sale deed dated 3/1/1956. With respect to Schedule B within bracket Roman 2, it was asserted that the land was exclusively acquired by the defendant number 1 in the year 1954, 1945, and by that time the original plaintiff had not even come to take it. With respect to Schedule B within bracket 1, it was asserted that the same was his self-acquired property from the recorded tenant. It was with respect to with the inboard property, the allegation made in the claim was denied. The defendant number 1 opposed the prayer of the plaintiff seeking partition of the scheduled properties to the plea by saying that the same were the self-acquired property of the defendant number 1 slash defendant number 1 and other co-defendants, but the plaintiff had nothing to do with those properties. In furtherance to aforesaid, with respect to some more properties, including the holding number 94, which is the subject matter of consideration in the light of the substantial question of law framed by this court. The defendant number 1 has made following statements in paragraph 21 to 26 of the written statement. इसको quote कर देंगे 21 to 26 of the written statement. As the court time is over, vote is case for limitation. कल लिखाएंगे बात. इतना हो जाएगा. आपकी स्टेशन.
नेक्स्ट केस है जो
आज तो नहीं.
उसमें एक प्लेयर था जो कि कंसेंट से आज हुआ था, अब कल ही एग्जीक्यूटिंग को डेट भी रखी हुई है.
कल रख. इसके बाद इस डिक्टेशन के बाद